Okay, let's get started. I see there's a bunch of people kind of coming into the individual waiting room. So rules of engagement here, we'll try to get in and out of this webinar in a shorter period of time. I know we have an hour allocated to this today. I think we'll probably land somewhere between 30 and 45 minutes. We really want to just cover kind of the biggest changes that have been happening specifically in privacy. This will be recorded. It will be available on our website. So if you have to jump off to get to a meeting or go to lunch, you can come to our website probably by tomorrow and it will be up and running. Separately, please don't be shy, participants, about writing in questions or raising your hand or putting things specifically in the chat. Ben, Kier, feel free if you see anything in the chat that you think is that's relevant, you can just grab it and answer it. If it's not relevant, you can also dismiss it too. That's fine too. So with that, let's kind of get started. So thanks everybody for coming to the latest version of the quarterly Reclaim Privacy webinar. We've got some experts here to discuss privacy as it relates to data, MarTech, and AdTech. I'm definitely not one of them. I will defer to Ben and Kier on this. I'm playing the host and moderator on this. So why don't we start off with some introductions? Ben, do you want to just let everybody know a little bit about you and what you focus on, and then you can hand it to Kier, and then we can run from there.
Yeah, thanks. It's great to be here. I'm Ben Isaacson. I am a principal with In-House Privacy. We serve as sort of a fractional privacy officers on demand, as well as outside counsel and outside privacy consulting. I've been in the privacy space since 1996. Earned my chops in Washington, D.C., doing stuff similar to what Kier's doing now. And great to be here. Happy to talk about this.
Awesome. Kier, over to you.
Sure, thanks for having me. My name is Keir Lamont. I'm with the Future of Privacy Forum. We are a think tank based in Washington, D.C. I'm on the US legislation team, which means I spend a lot of my time reading and comparing new privacy bills, statutes, regulatory frameworks, what have you.
Awesome. And so for those of you that don't know me, I'm Neil Sweeney. I'm the founder and CEO of Reklaim, who specializes in explicit opt-in data to really help platforms, brands, and agencies navigate the marketing landscape in Canada and the United States. So with the introductions now out of the way, there's a handful of topics for this quarter's webinar that we wanted to get to. I know in the last webinar, we talked about the pending US election. I think, gents, now that we're on the other side of this election, the obvious question is, now that we know what's coming as it relates to the White House, do we think that this new administration is going to have any material impact specifically on what we view as happening in the privacy landscape? Any thoughts?
Sure, I can lead off. I would say still a fair number of question marks of what it will mean with respect to the White House, who is appointed, what key figures are put in place, particularly with respect to who is named chair of the Federal Trade Commission, kind of the main privacy regulatory authority in DC. I think that could go in one of many different directions. Where I think we do have more clarity, though, is in Congress, where obviously the Republicans now control the Senate in addition to the House. So we have a unified government in Congress and with the White House. And we've seen some gavels change hands in leadership that could impact the privacy space and work on privacy issues from a federal perspective in some really key ways. I expect that many of your members of your audience will be familiar with the ADPPA and the APRA. These are two privacy bills that were worked on in the past two Congresses, which were viewed as very aggressive, very forward-leaning with respect to privacy, leaning very heavily into data minimization, strong default restrictions on what data can be collected and used, included a private right of action, had preemption, but narrowed in some ways. And looking forward, I think it's quite possible that the ADPPA framework will not be the starting point if federal privacy is on the agenda, if it's a high priority in the next Congress. One reason for that is Senator Cruz, who was ranking member of the powerful Senate Commerce Committee, will become the chair, most likely, of that committee. And Senator Cruz was very outspoken against the ADPPA model. He opposed empowering the Federal Trade Commission to the extent that Bill would have. He opposed the private right of action and expressed strong concern about those data minimization provisions. Over in the House, Republicans will maintain control of the House, but the chair of the House Energy and Commerce Committee previously was Kathy McMorris Rodgers, a Republican who was supportive of that ADPPA framework. She did not run for re-election, and it is unclear whether or not either of her likely successors, either Representative Guthrie or Representative Latter, will have a positive view of that framework. So for the first time since 2019 or so, the starting point for conversations about federal privacy legislation may actually be different, may take a different framework than the prior Congresses.
So two things that jump out, just Ben, before you probably want to add some color to that. There's always been this narrative around kind of an overarching kind of data privacy bill. Do any of these changes in the government, now that things are united, does that give any more credibility to that happening, or is that ship kind of sailed and we're dealing with the sort of the state level regulation as we have it now?
I think that ship sailed as far as the key aspects of preemption, which, I think for the most part is what we've been advocating for as an industry, to try and say, hey, there's this patchwork. I see the quilts on the back of Keir's wall. This patchwork doesn't work for us. We need a federal law. And I don't think, we're going to see a change in the positioning of California, in particular, the delegation there saying, no, we're never going to support strong preemption. And frankly, if we don't get strong preemption, I don't know where the momentum for a federal law really is going to happen. And I think maybe to Keir's point, I think maybe we go back to the drawing board and look at more AI specific or other sort of like sectoral specific laws that might have a preemptive aspect that wouldn't be the omnibus law we're thinking the ADPPA was trying to accomplish. But I don't think they're going to accomplish anything. That's my personal opinion. At least not in the next session. Maybe again, after the midterms, we'll see some changes there.
And what about some of the sort of more high profile kind of lawsuits that we've seen in the space, specifically around data? I mean, the one that obviously jumps to mind that's been in the trades quite a bit has been Location and Kochava. There's been a lot of noise around Location. What's our feeling as it relates to the new atmosphere and some of these existing lawsuits and the thought around Location?
Yeah, I think on the FTC side, I think that's the most important piece of this is that, I think we knew this even going into the election that Lena Khan's days at the FTC were numbered. On whoever was elected, I think on either side, there was a lot of momentum in lobbying. And so we are going to see a much more, I think, moderate FTC come in. And this Kochava lawsuit was really breaking new ground as far as Section 5 jurisdiction, where there was no harm, there's no gotcha, there's no silver bullet case here. So I would have to imagine that case gets settled pretty quickly in Q1, because I think they were trying to reach a settlement already. Obviously, Kochava settled on the civil litigation side of that. And I think they had already proven in court that they had strong positions, and where the FTC was forced to refile it. So I do see that case going away. I do see the rulemaking, the omnibus sort of rulemaking the FTC had initiated that didn't really seem to have a purpose or any sort of end or beginning. I see that going away. And a lot of their sort of really aggressive positioning around profiling, and even this, we could talk more about the Data Cleanroom blog that just came out. I think that gets more tempered into really refocusing the FTC back on harms. So I think a Republican FTC will go back to the old statute of like, if it's not harmful, we're not really going to regulate it. That may not be the case for big data and monopoly practices. That's a different story. I think we can segue into that separately, but I think the FCC will play a big role in that as well. But I think this sort of I think just the traditional, like the cases that we've been seeing out of this last 4 years of the FTC, I don't think we'll see some of those same types of cases in the next version, and maybe it'll shift over to the big data companies.
Yeah, makes sense. Your comment around the clean room piece was another bullet point that I had on the agenda here. That seems to be bubbling up, where there's been a bit of an arrow kind of fired here, where there's been some commentary around data clean rooms and whether they are actually as clean as they say they are, whether or not they're actually solving some of the privacy challenges. Can we talk a little bit about that? I know, Ben, you did have a big blog post specifically on that, and kind of where do you think the government or the regulation lands here as it relates to the clean rooms, and your point of view on this?
Yeah, and I mean, I think there's, and I was just actually on an IAB call about this a few minutes ago. I think there's a misunderstanding of what is a data clean room. Definitionally, what is a data clean room?
Some
And
companies might be doing that on purpose, but that's
yeah,
open
I
to.
mean, look, this goes back into every buzzword, CRM, CDP, whatever the acronym is. Like, there's going to be companies who are in a peripheral space that want to call themselves that. But the reality of it is, we should be looking at this much more similarly to like an email service provider under the Can-Spam Act. And that's the argument I would make, is that the software as a service clean room is similar to the email service provider that just delivers an email from point A to point B. And under the Can-Spam Act, we got this sort of routine conveyance language that I actually worked on. This is my big claim to fame back in 2000. And so, we pushed for that approach legislatively to say, hey, we're going to exempt the companies that are just the infrastructure, the building blocks, to allow two different companies or two different entities to talk to each other. And that's the way it really should be here. And I think California is a little tricky in the way that their law really defines CCBA, cross-contextual behavioral advertising, and the combination of data, and it's very sort of prescriptive, whereas the other, all the other state privacy laws don't really get into that level of detail. So I think in the other states, like it's crystal clear that a data clean room is going to be a service provider processor type function, and that there really shouldn't be any sort of scrutiny. California is its own beast, and I think the FTC has obviously taken a hard look at this, but from a perspective, I don't think they understand the default position of what a clean room is versus like, oh, there are these extra services and tools and things you can layer on, and even controls that may make it bad, which I think is relevant, but for the most part, everybody's trying to do good, at least from my perspective. So. I don't think there'll be that kind of scrutiny of those, at least of the providers themselves.
What I saw in that initial kind of filing was that there was this sort of commentary around sort of the sharing of data, which I thought kind of ran contrary to what exactly the clean room was trying to do, and that the clean room is not actually sharing data. I think the part that I've had conversations with other companies and brands about has been, while the various different companies might not be necessarily sharing data, you can access the data in a compliant way. What about the requirements regarding consent, adhering to all the regulation on how that data on the individual company and how they're ingesting that into the clean room? So those individual companies still have to abide by all the rules regarding privacy, consent, opt-in and opt-out. By just putting your data into a clean room, it does not absolve you from those requirements that you have. I think sometimes it's sort of viewed as the clean room. If you put the data in the clean room, everything is clean and everything is copacetic. To me, I almost see it as two steps. It's first is your data first and foremost has to adhere to all the rules and regulations. If it does, and it's in a clean room, then you're providing a service where you're not mixing and matching data. Is that kind of a fair assumption as to how I sort of look at it as it relates to the clean room, or am I making it too simplistic?
Well, I mean, it's the same as with any software as a service platform. I think there are bells and whistles and controls that each, and a business gets to use with that software. And it's the same thing for the consent management platforms. And this is an important point. I think maybe I'll even segue over to Kira, because I think these state privacy laws make it almost impossible to have a consent management platform that perfectly complies with all of the prescriptive language of California and all of the other state laws that call it targeted advertising or your opt-out signal, preference signal. You've got all these things that, again, the onus is on the publisher of the website pushing the CMP, same as the owner of the media platform pushing the clean room software, or the advertiser using the clean room software. It's going to be entirely up to them to create the controls that they need, customize them in order to comply with those laws. And do I have to process a preference signal for that particular state? in addition to, the cookie or the email-based, identifiers. And like, so it's very messy, I think is the point. And there's no simple answer here. It requires a lot of customization.
I guess, the question then we can move on is there's a lot of noise around the consent management platforms, and we see all the publishers sort of kind of dropping the consent management platform on the front end of their product. Is it possible for the consent management platforms to stay up to speed on the various different changes as they're happening in privacy? Is there a consent management platform that solves all of these various different state level challenges as it relates to privacy, or is it a bit of a game of whack-a-mole here for the CMPs and trying to solve that issue for the individual publishers?
Maybe Kier, you can handle that one.
I think you are much more familiar with this space. I think clearly in the States, many more laws being passed, so inherently it's going to be a moving target. And we're still at an early stage where there haven't been many enforcement actions, and it's not necessarily clear how every regulator is going to interpret every aspect of these nuanced differences, or even the same language between different state laws.
Okay.
I think that the basic thread is that, you see this in your own experience on the web. Every website has a different cookie banner. They're all different. The language is different. The options are different. The patterns, dark patterns or whatever they are, like there's a million different approaches to this. And, in Europe, we've gotten some prescriptive guidance from the regulators. We're going to have to get that guidance here in the US. I think that has to come. And again, these new regulations out of California start to get there a little bit, even if they're like way overbroad or too prescriptive. But, I think we're to Kier's point, we're years away from having clear guidance.
Okay. Well, let's move to California. There's been some changes here in CPPA. Do we want to talk a little bit about some of the key takeaways and implications from the latest discussions and updates around this?
Like, I hear they're hiring an executive director. Maybe that's the first.
Besides that,
Sure. Would you like to start data broker side or generally applicable privacy rule side?
well, I mean, for me, the data broker piece always kind of comes up. I mean, I think just to kind of to frame it up, the whole notion of like the registry of data brokers, which, various different companies have signed up to, is there any change in that? And I think there's also been some discussion around this overarching kind of delete me concept. So are we moving to an environment where if you as a consumer sign up to the California Delete Me, that you will actually be finally removed from the thousands of data brokers that are registered? Or are these two things still underdeveloped, non-functioning, and kind of our figureheads? I think let's sort of start there as to what's different here for the registry, data brokers, and Delete Me, and then we can move on from that.
Sure. So on the data broker side, I believe California has had a data broker registry since 2018, 2019. If you're in the data broker business, you have to pay a bit of money. Your name is put on a big list of different companies somewhere on a state agency. Not a whole lot of impact necessarily beyond maybe you're on this list, potentially a list of shame, but depends on what your perspective is. That changed somewhat, I believe, in 2023 when California passed the Delete Act, which transferred authority for this registry over from the California Attorney General's office to the California Privacy Protection Agency. And the CPPA just finalized some new regulations about who has to register for this list. So basically, the law says if you sell personal consumer data, and that definition of sale is arguably broad, it's sometimes contested. If you sell personal data of consumers who you do not have a direct relationship with, then you have to register for this list. The big change with these recently finalized regulations, although there are still some procedural steps to go through there, is to say that if you sell any data of consumers and you do not collect that data directly from the individual, no matter what other relationship you have with that individual, you do not have a direct relationship. So potentially this could significantly broaden the number of companies that have to sign up for this to get on the registry. Now, you mentioned this delete me concept, and as part of the Delete Act, the agency is tasked with building out this new accessible deletion mechanism, a one-stop shop where a consumer or their authorized agent can submit a request, and everyone who's registered as a data broker in California has to delete any personal information they have about that individual. That's something that's still needs to be built. It's underway, and the agency actually voted to raise the registration fees in California from about $400 to a bit over $6,000 to get on this list. And we'll use that money, which is a fair amount of money, to pay to build this registry. And so a big concept here and a big thing that still needs to be worked out. Okay, having bulk deletion rights and tools and being able to exercise your privacy preferences at scale can be very beneficial for individuals, better than going website by website, app by app, navigating little tools and exercising your privacy choices. However, it now really matters, what are the businesses that end up on this list? And what data will those businesses have to actually delete in response to these bulk requests? And if that includes first-party data, the photos you provide to a photo sharing service, account information, this could be very much a bulk, blunt instrument that actually cuts against individuals' preferences. So there's still work to do at the agency to like figure this out and get this in place by the time this bulk deletion mechanism is scheduled to go live in a couple years here.
So we're still a bit of a ways out until this
Well,
delete.
it's happening, and it'll happen quickly, I think, is faster than we think. I mean, they've already proposed, sort of the framework for and the timeline for how they're going to, engage in like an RFP to, bring in the technology providers to be able to create this drop mechanism, this deletion mechanism. The reality of it, I think, we already have a framework from the FTC do not call list, and we've got Can't Spam Act suppression tools out there. It won't be that hard for them to build this thing, I think, is my summary. And the cost that they've presented may be much higher than is necessary. And I think this is where there will have to be some sort of collaboration between the entities on the registry and the CPPA, in addition to the RFP process with the vendors themselves. Because, yeah, to Kier's point, the huge jump in the fee for these data brokers, many of which, and I work with a few of these data brokers, are kind of small businesses. These are not, some of them are like mom and pop kind of entities. Like there's not a lot of friction in terms of becoming a data broker, except now that $6,500 is a significant burden on that business, and is obviously a state-specific burden that maybe there are other states. There are 5 other states with, or 4 other states with laws on the books, with similar registries. We get into sort of a interstate commerce clause kind of question, dormant commerce clause question on the legality of that significant fee, which is sort of a tax on those businesses. So I actually have serious legal questions if they can hike that fee legally, and whether there could be some sort of constitutional challenge to that. That said, there are probably providers out there, again, coming from a world that have been, data clean rooms, for example, even that we just talked about, that can already offer this type of suppression or deletion mechanism for significantly less than what they're budgeting right now. So, we'll see how this plays out in the next couple of years, but it could be fraught with some headaches for sure.
What's the timeline for their RFP process for that going out? Is that documented?
Yeah, I mean, it was in a slide deck they released with the meeting. I think it should be on their website. But I think it's within the next few months they're going to start kind of building out their RFP and release it early next year. So, and then I think it's about a year to build it out. So.
I would also just note, though, that California has not always met statutorily envisioned deadlines for getting even things like regulations out, and building a whole new thing of this magnitude. I wouldn't necessarily expect all those dates to be hit.
Any feeling that California is sort of the blueprint for the other states as well, and that what they're trying to do here with Delete Me and the brokers? I mean, we've seen this with some of the changes regarding sensitive personal information, et cetera, kind of manifest in other states. Do you guys both think that what they're doing here with some of these changes is going to create a bit of a foundation for what other states might enact as well?
It's something to track. I think certainly the law, as we mentioned, passed in 2023. This year, I saw only one state try to run a similar type of bulk deletion request framework. That was Tennessee. That bill never got a hearing. But as California actually gets closer to setting this up and we get closer to individuals actually being able to exercise their delete rights on a kind of global scale, I would expect lawmakers in other states to start paying far closer attention.
Yes, I would, yeah, take special note of the ones that already have the registry. So in particular, Oregon and Texas have registries where they have sent letters to the entities that have not registered with Oregon and Texas, but have registered with California, and it's on their California website. So I've had clients get those letters. And there are various reasons why, you know, you may not want to participate in Oregon's registry in particular, because there's an interpretation that, you know, that you have to comply with some significantly additional onerous requirements for the sources of those data providers to release the names of everybody who they sold the data to, which is, you know, a big burden, new and unique for Oregon versus the other states. Where I do think, again, if California can make money doing this and make a big stink out of being this privacy leader, other states will follow suit. There's no doubt. Yeah, there's not a lot of lobbying against it. Honestly, like the data broker industry is extremely weak as far as lobbying power goes. We used to be, you know, stronger under the Direct Marketing Association, you know, for 80 years of the DMA, but the DMA is gone. The ANA isn't really championing this stuff as much. So there's really not much of a coalition to fight it as there used to be.
The IAB seems to be in support of the data brokers based on their stance.
They're trying to play a little more of a middle ground, I think, because they represent, you know, a lot broader ecosystem here. And, you know, again, there's a difference, and I think to your point maybe earlier, like there's a little bit of a difference between data brokering of cross-contextual behavioral ad data versus data brokering of, like, you know, potentially sensitive segments or, you know, other segments that are more demographic related.
Yeah, two questions on that. So in these changes in California, any impact on behavioral ads and kind of what's going to happen there going forward? That's one. And then maybe a bit of a romantic idea is that if California actually gets down this path and builds this ecosystem where there's this, you know, ubiquitous delete me, why would these other jurisdictions build their own independent ecosystem? And is there any possibility that those states like Texas who already have these registrations could just piggyback on this pre-existing delete me? And so you're getting kind of almost by default this multi-state delete me versus this, again, fractionalized patchwork of kind of opt-outs. Any possibility that happens, or no chance because everybody is kind of thinking only about their individual state?
I mean, this is a huge issue. I could probably spend a long time on it because I think it's so important to clarify and I think we'll see in this RFP process that these are California residents and they have to prove that they're a California resident. If they get rid of the California residency verification, then I do think there's a very strong constitutional challenge to this this registry. That I would think
constitutional challenge, meaning what? What do you mean?
Meaning it's a burden on interstate commerce. You know, it's an unfair tax, and it's a, you know, again, there's First Amendment issues as well. Like there's a lot of other claims that you can layer on to say, you know, California, you can do this for California, like fine, you know, and even with cookies and you know, consent or whatever, like you've got IPGeo, like there's ways to sort of identify in California. You can't do that with if you have an email address, for example, and you're an email list data broker, you have no way to know this is a Californian versus an Oregonian. And so if they give a driver's license or whatever it is, fine, you know, they'll do it. But then yes, it'll encourage Oregon to do a data broker registry of their own. If California pretends like this is really the national database, then I think we have to address that, you know, in court. I think I'd like to see it at least clarified.
Interesting. And then to the behavioral ads component as it relates to California, any commentary on that regarding some of the updates regarding CPPA?
Yeah, I can jump in on that first. So in addition to finalizing and laying out a strategy for data brokers and bulk deletion requests, the agency also voted to initiate a new rulemaking process for generally applicable privacy rules. So kind of if you're covered by the CCPA, no matter what industry you're in. And there's many important pieces to that. There's opt-out rights with respect to automated decision-making technology, new rules around risk assessments and short-form risk assessments that have to be submitted to the agency, new rules around cybersecurity audits. So those are all really big deals. When it comes to targeted advertising, the general approach under the CCPA has been the creation of an opt-out right for what's called cross-context behavioral advertising. And Ben mentioned that can be a bit of a murky term in and of itself. But generally, the idea is you can opt out of receiving ads based on data collected about you kind of across the internet on multiple websites. The agency now is trying to do something new here and create an opt-out right again for behavioral advertising based on first-party data, based on information that a business collects directly from you as you use its website or its services and no one else. So that would be a really big shift. And it's very interesting that the agency is attempting to pursue this under its authority to regulate automated decision technology and not under its inherent authority with respect to online advertising. So I think it was very interesting watching this board meeting and seeing something like 40 different industry groups all come in and say, whoa, 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 there was a compromise. There was an understanding that went into passing the CCPA and the vote on the CPRA amendments to that law. And the understanding was opt out of third-party targeted advertising, not opt-out rights with respect to that first-party advertising. So there's going to be strong pushback to this, and very interesting to see whether the agency continues to stand by the creation of this new opt-out right, or maybe it's pulled back somewhat in future iterations of this new regulatory package.
So,
Yeah,
so why the change? I mean, just before you jump in, Ben, like, so why the change? So they're clearly moving the goalposts a little bit. So they're doing so with some sort of agenda. What's the baseline agenda that they're trying to capture with this movement?
It's hard to get beat. It's such a subjective question. Like, I don't know, honestly. That's so hard to fathom. And I think the most important point, what Kier just touching on what he said, was some of that pushback in that meeting even came from Alistair McTaggart, who was the author, or at least the champion of the CCPA from day one, saying this wasn't what we anticipated in the law. And so if you have the author of the law saying, hey, we're driving outside our lane here, that speaks volumes as to what's happening here about the rest of the whole rulemaking process.
I guess I'm just confused as to why they would change it if they had kind of a somewhat agreement around the way it was going to move, and then they did a bit of a got you. Seems like somebody got over their skis here a little bit and tried to.
I will say the agency did release a document, the eyesore. It's very hard to see. It's hundreds of pages. That stands for the initial statement of reasons, and I'm sure a justification is included in there. So I would not want to speak without reviewing what the agency's words were for pursuing this expanded opt-out right.
I think I did mention that they're hiring a new executive director. Maybe that's not a coincidence.
Are you applying?
Yeah. I'm not applying for that job, but at least not until my kids are out of college. Maybe then I could do it.
I like it.
But
All right.
I think the biggest issue, I think, to just coming back to this rulemaking, really redefines profiling or extensive profiling. This new definition of really extensive profiling that really touches every at least big first party that has big data, that has a lot of data about customers. So I don't think that education has been really widely disseminated. Is that, if you're a Fortune 500 company or Fortune 1000 company in America, this will affect you in a much more material way, because every company has been doing extensive profiling of their customers for marketing or acquisition, lead gen, whatever it is. That now all of a sudden, like, this is the new FTC. This is a much more national regulation than I think anything we've ever seen in the history of, at least in my opinion, the history of state privacy regulations. That definitely changes the game, you know, in a big way. Again, this is draft. It could obviously change, but I think that the most important thing is that every Fortune 1000, every company that has a lot of data pays attention to this and gets involved in the rulemaking and starts to lobby against this sort of first party data focus. Um, and we can live with the third party data, I think, you know, opt out. I mean, all the profiling that's been used for third party data targeting, like, or cross contextual behavioral ads like that. You know, the industry's gotten very, very good at managing those opt outs, and even managing, you know, trying to do better with the CMPs and notices and things like that. But this first party stuff is really sort of a deal breaker.
Hmm. And then in some of these changes or in this draft, are they starting to intersect with some of the new ideas specifically around AI and where data is being collected there? And I mean, it seems as though I've always said that kind of data and privacy and AI are on this kind of massive collision course. Maybe we can segue into that as to how do these new changes in California impact kind of AI data collection, and are we seeing similar types of situations in some of the other states, whether that's Texas or Colorado? Just maybe for the audience, give them some understanding here as to kind of what direction the privacy law is going as it relates to data, AI, and specifically around training.
Yeah, that's a really complicated topic. As I mentioned, this rulemaking covers opt-out and access rights with respect to automated decision-making technology. In a lot of the different states we've seen, they've adopted a lot of European language and concepts and created opt-out rights with respect to automated processing that results in legally significant decisions. California seems to be taking a far broader approach and creating opt-out rights for things like that behavioral advertising that we discussed. For, I think Ben mentioned, is it extensive profiling and things like public places in the workplace, for example, and opt-outs of training for ADMT. So that goes a bit further than the other states. But other states are also passing laws that focus on these issues as well, that are kind of AI-focused laws. And so we saw one enacted this year in Colorado. We've seen a draft bill come out in Texas quite recently. And I think a big distinction between how some of the other states are proceeding and how California may be proceeding is that California is opt-out first. If there's an automated decision-making technology being used, you inherently have an opt-out right. Some of these other states are taking an approach where it's more of, if you are subject to an automated decision that is biased or inaccurate, you have a right to contest the result of that decision. So big kind of practical questions about how do you operationalize at scale either opt-out rights in California or these rights to contest, which seem to be how other states are more frequently approaching this concept.
Yeah, and you know, to the CPPA's credit, they released a little fact sheet guide on it. I think maybe I just posted it to the panelists, but not.
I put it in for everyone.
Well, I think you maybe put in the text, not the other one, the guide. So you know, and I think there are categories of automated decision making that really do have disparate materiality to the individual. And I, you know, again, this AI stuff, I think I've talked about with a lot of, you know, companies. Some of it's not really new, I think, as far as what the CPPA is really advocating here. That falls into like what I would call like the Fair Credit Reporting Act type requirements that we've had on the books now for, you know, 40 plus years. Where, you know, if you are making a decision, like again, about someone's reputation, and I think they're, you know, the CPPA is really getting into some good territory here around, you know, filtering like resumes and things like that, or, you know, again, anything that that could have a direct human impact at an individual level. Where I think, you know, that there's a bright line between some of those human impact issues versus like the advertising profiling or advertising targeting, which is more ephemeral and not really, you know, typically, I think as individually profiled as people think that it is. It's really categorically profiled, not individually profiled. But I think that there's a lot of work to do to kind of split out those types of areas where you know, they're saying you can't opt out of this profiling for behavioral advertising, and that it's sort of hard to understand where the CPPA is coming from on some of that stuff, where they're so focused on this advertising piece instead of really more the human element, where I think there is a lot of room to grow. And I think, you know, Colorado and some other states have passed laws where they're really focusing more on those types of issues than I think on advertising.
Perfect.
I don't know, Kier, you want to touch on the Colorado law, or you're probably more familiar with it? Um,
Yeah, past this year focused on developers and deployers of what they call high-risk automated decision-making systems. Lot to unpack there, but potentially something that we'll see as a template that could pop up in other states. And I think some kind of open questions about whether or not advertising practices would be encompassed in frameworks like that. When it comes to a consequential decision, if it's just something that results in the provision or denial of an important life opportunity, housing, education, healthcare, etc. Probably not, but in some of these frameworks, they encompass systems that impact access to those opportunities. And then there's questions, do the ads you see, if it's an ad for a apartment complex, does that impact your access there? So I think a lot of question marks in this space still, and something we'll be tracking very closely going forward.
For sure, evolving. So just before we kind of wrap up, as we're heading into 25, what's the big theme of 25? Do you guys have a what's to come, or what should we be watching as a theme for 25 as it relates to data privacy and some of the changes that we think that are on the horizon?
So I'll lead off, and I think it's the concept of data minimization. So in a lot of the state laws that have passed up until this date, maybe some nuances between them, but industry generally understands the intent is opt-out rights with respect to online targeted advertising, and there's general data minimization rules that say don't use data for reasons that you don't disclose to your customers. Maryland passed a law this year that will take effect next year that is either paradigm shifting or business as usual, depending on who you talk to. And they attempt to take a very different approach with respect to data minimization. I will try to be a bit technical here, and I apologize for this, but it's very complicated and it's very important. So Maryland attempts to go a step further, and I'm using attempt deliberately there. And they say you can only collect personal data if it's reasonably necessary to provide a requested product or service. You can only process sensitive data, so processing is broader than collect, as strictly necessary to provide that requested product or service. And there's very more stringent restrictions on selling sensitive data. And as we know, that definition of sale is contested. So obviously a huge question here, how does online advertising fit into this model and paradigm? You'll have people who will say, look, online advertising is inherently always going to be secondary to why someone is using a product or service. You're also going to have organizations that say, look, the only reason we can provide our online services because we monetize by targeted advertising. So obviously our practices for advertising are necessary to provide that requested product or service. In Maryland, unclear where the chips are going to fall, to be honest. But this framework, we've seen language like this get very close to being enacted in other jurisdictions. Got very close in Vermont, actually required a governor's veto not to have this enacted. In Maine, it came down to the last day of session. So I'm very interested in seeing how these new data minimization standards in Maryland are interpreted, implemented, and ultimately enforced, although enforcement is still probably many years off here, as well as whether or not this becomes a template that other states pick up and pass in some capacity.
It seems as though, just before you jump in, it seems as though like every quarter, kind of there's one state taking kind of the top of the podium. You know, I think last quarter we were talking about Washington, my health, my data, and how everybody was very confused as to how do I operate as it relates to Washington. And so we've seen this amongst a variety of brands, platforms, and agencies where because they don't know how to operate in those jurisdictions, they just stop marketing altogether in those jurisdictions, looking for some guidance as to how to do that. And I've kind of often said that if Washington was getting kind of the majority of the narrative, Maryland is now kind of the state that I think is going to go to the top of the list here and start to get all the attention. As to, if you think California was bad, then you have Washington. If you think Washington was bad, wait till you see what we've got in Maryland. It just seems like there's this sort of escalation that's been going on. Sorry,
And I would
Ben.
just say I'm still confused about California and Washington, so still work
Yeah.
to do in this space.
Yeah, and I'll layer on again that data minimization, I think, aspect of Maryland is also built into these draft regulations in California. This reasonable expectation of what happens when you collect data on a website. And again, there's the inverse of that is like, oh well, we'll just improve our CMPs, we'll improve that notice of collection. You're going to get bombarded with it on every website you visit now, and it's going to be like 10 pages long, and you're going to have to click through, and it's going to look like a mortgage application, but there won't be any question that it's reasonable at that point, right? And so it's like, well, who are these regulations for? Are they really for the consumer who's going to get an e-sign on a cookie banner? On every website they visit, because that is what the lawyers are going to demand of every website you visit, because that's the way to make it reasonable. And so, it's really not in the best interest of the end user here. But I do think, the Maryland paradigm, I think, is very important because of that, that ban on sensitive data selling, which is a totally unique concept, I think, in America, to ban a business from engaging in what has historically been a common marketing practice. Now, again, sensitive data is a pretty big category, and there's a lot of things in the definitions that we should pay attention to, as well as privacy by design, as far as is this really individual level data, or is it more aggregate, census level data or something like that. But so there's a lot of nuances there that I've had to work with a lot of clients on, because including Washington and other states that have these kind of restrictions on sensitive data. I think the big category, though, is location data. And I think that's where, we've seen these FTC cases that are very important, these consent decrees, really, I guess I would call them. We've seen, again, the focus of the regulations, and we've seen pretty much every state say, GPS data is sensitive. Now, there's a lot of finger pointing here around, well, why are these cases happening? Why does this industry even exist in the way that it does, with this sort of ubiquitous sharing of GPS data? And I would point fingers again at Apple and Google in particular, in the way that they've, built out the operating system for consent for GPS data. And the fact that, again, these apps, and again, are only now just rolling out CMPs, years later after GPS has been implemented, to say, okay, well, if the operating system isn't going to offer genuine consent for this, then we need to do something on top of that. But ultimately, I blame the operating system for this. I think Apple in particular has been a little two-faced around this issue of, say, and again, with their app tracking transparency framework in the same genre, where the publisher of the app cannot customize the consent mechanism to say, not only are we collecting that consent for our first party use, but we are going to share it with third parties, and you can opt out right now. So if that was a mechanism that was built into the OS, I don't think we'd have any of these location-based cases going on, or even the need for location-based regulations. But unfortunately, it starts from the beginning of the upstream flow, and then but now, because of obviously anti-abortion, all these other issues going on, that have put the onus on health, as a location issue. The rest of the industry is now being impacted heavily by it.
Interesting. Okay, we're getting up here on time, so I'm conscious of people have got other things to do during their day. So why don't we kind of pause here? Maybe if you guys could just, if listeners wanted to find you, Ben and Kier, what's the best place for them to reach out? Is it LinkedIn, et cetera? Maybe Ben, you can kind of let the group know what's the best way to connect with you, and Kier, same thing. And hopefully everybody that's here hires you guys to work on all their privacy stuff for them. So Ben, why don't you start?
Yeah, I'm on LinkedIn. Ben G. Isaacson is my profile. I think I can throw it in the chat. I try and publish stuff there as regularly as I can. Yeah, happy to talk to anyone about this.
Perfect.
I'm also on LinkedIn. Not many killer months out there, so I'm sure you can find me pretty easily. I do a fortnightly little newsletter on LinkedIn. All the big state privacy and AI updates could be a helpful resource to folks in this space. I'm also trying out Blue Sky, so if anyone wants to connect there, I'm looking for new connections on the new social media app. So
How's that been? Has that been good so far for you?
I think scales up quickly if you get in the right starter packs. So we'll see if people start engaging a bit more.
Interesting. And I'm Neil Sweeney. If you want to reach out to me, you can find me on LinkedIn, Twitter, or neil@reclaimyours.com. Thanks, everybody. Appreciate the 50 minutes here to kind of burn through some of the top issues. We'll see you next quarter. Thanks, everyone.
Thanks, Dave.